Your views matter.
रेडियो जिंदगी 1170 AM पर वेलकम लिसनर्स, मैं हूं आपके साथ में ईरा एंड वेलकम टू द शाह पीरली लॉ शो. Shah Peerally is the founder, president and managing attorney of the Shah Peerally Law Group, which is based right here in Newark in California. He is a member of the American Immigration Lawyers Association as well as the State Bar of California. He is a passionate advocate of human rights, civil rights, social action and social services, and he has a strong knowledge of and interest in the political and legal system in the US. He formed his law group to work on the causes that he feels most strongly about. The law group focuses on immigration law with an emphasis on employment-based immigration, and he does help his clients all over the US. Offices are in Newark, San Francisco and Washington DC. तो listeners, अगर आप उनसे बात करना चाहते हैं, खास करके employment based immigration को लेके आपका कोई केस चल रहा है या कुछ शुरू करना चाहते हैं, या if you want second opinion, you can definitely get in touch with him. आप फोन कर सकते हैं during the show on 510-657-1170. That's 510-657-1170. अटॉर्नी शाह पीरली का ऑफिस नंबर है 510-742-5887. That's 510-742-5887. ऑफिस न्यूयॉर्क में है. अपॉइंटमेंट लेके आप बात कर सकते हैं, और अगर आपको ये सारी इन्फॉर्मेशन चाहिए, एंड इफ यू कैंट रिमेंबर, बट ऑल दिस इन्फॉर्मेशन इज अवेलेबल on the website peerallylaw.com. That's peerallylaw.com. peerallylaw.com. So without any further ado, Attorney Shah, welcome to the show. How are you doing?
I'm doing well. Thank you so much for the intro, and welcome to all our listeners. This is Attorney Shah Peerally from the Shah Peerally Law Group, and today we're going to have Sharif joining us a little bit later, Ira. And before I start, of course, anything I'm going to tell you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions, and of course, you can call us 510-742-5887. 510-742-5887. And today we're going to discuss, of course, the topic of the town, so the two is the election, first of all. And this is where everybody is getting totally confused. So many forecasts, like some people who are saying that for sure Biden is going to win, which I don't think exactly like that, but at the same time some are saying no, clearly Trump is going to win. But last time we had an election, everybody was bidding on Hillary, and again things changed the last minute, so you have to be ready for anything. And of course this is going to affect immigration, and people should go and vote. That's the main thing. If you are a citizen, you're not voting, you really have some issues.
Yeah, I was actually talking to somebody yesterday, and I was asking them, did you vote? So they said, what's the point of voting? Trump is going to win anyway. So they're not these, I think they're Biden supporters. So I said, fine, even if if you think Trump is going to win, if you don't vote for, whoever you think, Trump is anyway going to win. So if you want, like, how Ms. Renu always says that if you don't vote, you lose your chance to complain. So might as well go out there and then see what happens and how it goes from there.
Exactly, and that's how it works in a democracy, right?
Yeah.
We got to participate, right? Because later on we will have to explain to our kids when they ask us, hey, why did you not do anything?
It's a right, it's a duty, and it's a privilege at the same time.
Exactly, and this is where sometimes I understand people are really frustrated, but at the same time, it is very important, because now this time it's going to affect your not only your life, the future, the planet itself. Yeah, especially with all they're backing off from so many environmental issues, political, and it's going to be a mess. If there's another term of Trump, definitely, and not to say that Biden is better. It's just like I'm not also a fan of Biden, but at this point in time, got to make a choice. So, having said that, this is my opinion again. But you got to vote. Whoever you vote for, you got to vote. So that's the important part. The second topic of the town, of course, is the EB2 timing, and a lot of people don't know what will happen next because we are now October 21st, and the new visa bulletin is not out, unless I'm wrong. It is not out, so usually when we see those kind of things, we are either expecting a jump or a retrogression. Since we saw a jump last month, well, for this month, we might see a retrogression for November. So be ready for that. This is something that we were expecting, but I was hoping it would stay for another 3-4 months. But let's wait and see. But this is my take on it, because usually, whenever you see a jump, you should, especially when something like that, which is very, very rare, you see a retrogression coming just after it. So be ready for that. And this is again just my opinion. You should not kind of take it for granted, because this is just a forecast. Now, the second topic that is really big is the H-1B, of course. H-1B now, as you know, the new rules have made it very, very complicated for many people, because for one, the salary itself has become so high, in some cases almost 92% higher, which is really unaffordable for most companies. And that, because of that, when people are doing transfers or extensions, they are not able to really get an approval, because the companies cannot afford to pay salary. For example, a salary of 50,000 can turn to be 100,000, and most salaries are not 50,000 now. For H-1Bs, it's almost close to 100. So we're talking about 150, 175, which is really not bearable for many companies now. And that's not really realistic, because in the field, nobody really gets that kind of salary. So, and that's really the part which is really kind of frustrating a lot of people. And also, for those who don't know, they changed the system now, making it very difficult for people who are what we call on a specialty occupation, which is very, very tricky, because a specialty occupation is not. We used to be able to explain that in different ways, and now with this new rule, it becomes harder in certain positions to be qualified in a specialty occupation, which means no H-1B, because without a specialty occupation, you don't get an H-1B. So be ready for things which are really kind of weird. But the good news is 13 companies just filed a lawsuit. I think 2 days ago, they filed a lawsuit against the Trump administration, which so far has worked very well, because all the laws he has pretty much passed, not all, but many of them have been blocked by federal judges. By the time it reaches the Supreme Court, we don't know how things are going to unfold. But until then, at least we have some kind of relief. So don't desperate and just give up, because right now things might get better now, except of course the COVID is coming on I don't know, I keep hearing second wave, third wave. I'm confused, because I thought the second wave already came. Now they're talking about the second wave, but we need to be ready for that too, because all this are affecting definitely what's happening to all of us. It's not only about the ability to really kind of go to work, for example, and many businesses have shut down as a result. Someone said COVID killed more businesses than people, and it's kind of true, unfortunately. Yeah. The tourist industry, which employs almost 60%, I think, of the workflow of the world, is completely on its knees, right? Very few countries are accepting tourists, and even if they are, most tourists are not willing to travel, because they don't want to really take the chance. And worse, the cruise lines, which were one of the biggest money-making machines, are now almost shut down. The few people taking them are getting sick too. So all these are going to affect. How does it affect most of our people? Definitely it does, because what happens is that most of those companies do have software engineers, do have analysts, do have financial people who are all pretty much under H-1Bs or under a green card. So it is important that people understand that all those things are getting really kind of taking a toll, definitely, on our entire system. And that means immigration also is affected, and unfortunately, but unfortunately, we're getting a lot of course, people just losing their job. But the good news is that some organization or some companies are actually hiring more than, especially in certain national interest fields like in the medical, in data research, in DNA research and stuff like that. Many people are actually kind of getting hired. In fact, they are booming because they are all related to COVID. So you need to really kind of think outside the box, because if you don't reinvent yourself, you're going to see yourself into a very difficult times. But the good news is that most of our people are still doing okay, and that's really it's unfair for the other people, but at least we know some groups are doing okay. Now, again, ladies and gentlemen, today we're going to have Attorney Sharif hopefully with us. We're going to discuss about this EB3 situation, because a lot of people have been jumping on the EB3, right? As much as it's a good choice for many people, even our law firm are doing a bunch of them. Having said that, EB3 is just a band-aid right now. To be honest with you, it might never really come up to the real final action date. I'm not saying it might not. It will come ultimately, but it might not come so soon, because now when they're going to get all this influx of cases, things are going to go backward a little bit. And what will happen to the final action rule is very important. One of the questions I get very frequently, people who have children turning 21, if you have a child turning 21, the filing date doesn't lock the case. I repeat that. Let's say, for example, the child is 20 right now, and your filing date is current, so you will be able to file an EAD for that child, an adjustment of status. But until the final action rule is the date of the date like we have right now, 2015, you don't really lock the child under Child Status Protection Act, which means pretty much once they turn 21, they're pretty much going to be on their own. So you need to find a solution for them, and we can help you on that. Sharif, I think, right? Sharif, are you there?
Yeah, hey, Attorney, how are you?
Hey, Sharif, assalamu alaikum. How are you? How's everything?
I'm doing well. How are you?
I'm doing well. So tell me, Sharif, what's going on what's going on your side, and how things going, and what are we expecting now with because the EB3 has been like the El Dorado, but it's not really going to be lasting forever. So people have to have a backup, right?
Exactly. Yeah, I think that we are again seeing delay in release of the monthly visa bulletin. Which was expected, again, because there are changes. So the question is going to be whether all of the data is going to be collected prior to the issuance of the November bulletin. So if, for example, they know how many downgrades took place up to a certain point in the month, or what they do is they will see, for example, let's say until the 10th or 15th of the month, how many downgrades took place, then they project it over the course of the entire month and make a determination of what the visa availability is going to be. I predict that you're going to see now retrogression with respect to EB3, and obviously that's going to, harm all of the people that jumped into the EB3. Now, it's not a total loss, because you still will likely, because you have your adjustment of status in, you still will likely be able to get the work authorization, I-765 employment authorization document. However, it is highly unlikely that, it will progress to the point where we'll be able to get the green card. So I think that part of the concern that folks have with respect to the final action not coming into fruition is well-founded, and that ultimately we will, hopefully folks will get an EAD card, but it's doubtful that they'll get much more than that. And I think there's some ways that you can protect yourself. Certainly anyone who's doing a downgrade, particularly those who are, in a position where they, have a high salary, where they are, very advanced in their career, it is an absolute requirement for you to file a national interest waiver. I think you should, really, make sure that you are filing a national interest waiver if you are doing a downgrade to EB3. Because, first of all, a national interest waiver is available whether you have a master's degree or not for most people because of what's called the E21 classification. And not to get too deep into the weeds, but ultimately a national interest waiver is an EB2 self-petition. So it's something that you could do on your own. You don't have to tell your employer. And it will allow you to basically maintain not only the EB3 classification, but also maintain the EB2 classification at the same time. So that if the retrogression takes place in EB3 after you have filed and your date is current for EB2, you are not in a compromised situation. Because what will happen is if your employer has downgraded you to an EB3 so that you could file the adjustment of status, and then in subsequent months, the dates for EB3 retrogress and dates for EB2 advance, well, guess what? The employer is going to have to file another I-140. And I don't know that they're going to be so inclined to do so, having already spent attorney fees and government fees on downgrade. Will they do the same to upgrade you back to EB2? That is an open question because you can only have one labor certification at a time. So it's not like you can have EB3 and EB2 at the same time. So the solution for that is to file a national interest waiver.
I just wanted to make a point here, Sharif. Sorry to interrupt, but a lot of people, what has happened in the past, they have filed two labor certification with the same company. So they have sometimes an EB2 and EB3. Technically, if you look at the regs, it's not very clear, but you're not supposed to have that. But still people have it. But in the case that we're talking here on downgrade, you cannot have one labor certification with two I-140s on it. But if you have a national interest waiver and a labor certification, guess what? There's no conflict. And that's what exactly you're talking about. And this is why I am now encouraging people to go for national interest waiver, because first, you don't disturb the employer. Number two, you don't depend on the employer. And later on, if you're doing AC-21, moving the case from one company to another, you can still use your national interest waiver when EB2 goes better. So national interest waiver is a gift that is yours. Nobody can take it unless there's some kind of major fraud or something, which will not happen. People should really look into the national interest waiver. Sorry, I just wanted to add this in there.
No, you're 100% right. Thank you for that clarification. And it is such a powerful tool in the immigration toolbox in terms of the national interest waiver, because particularly those now downgrading to EB3, they have now an approved EB3 pending adjustment of status, and they can also have an EB2, so if those dates become current. But even without that, having a national interest waiver is really powerful and great, because if anything happens, let me give you a small scenario, and I've seen this so many times, is while your adjustment of status is pending on an EB3, you have to file what's called I-485 Supplement J. That is basically the employer is verifying that the job offer and that the position is still there. So if there's any sort of loss of job or layoffs or what have you, while your I-485 is pending, then this could undermine your ability to eventually adjust status. Now, if you have a national interest waiver and the EB2 dates become current, then you will not have that issue because there's no job offer requirement for a national interest waiver. So it is much more advantageous position to be in than to be dependent on the employer. So that is something to really think about and consider for those of you who are in the situation where you are downgrading and your employer is doing so for you. So this is really important. I think right now, I would say this is the most important thing that you can do to protect yourself and your family is to file that national interest waiver. And I know it's costly in terms of, fees and what have you, particularly because it is a self-petition. Of course, we will work with you in our practice and try to accommodate, but ultimately you want a approvable petition, and that approvable kind of petition does certainly take time, energy, and efforts to make sure that it's successful. So, we're not just going to be paper pushers and submit, things that you already have. We want a very detailed, analytical framework that we use to make sure that each case is handled on an individual basis. So that is something that folks should be, able to benefit from in terms of the national interest waiver. The other very, very important point now is that they have expanded the premium processing to include national interest waiver. So if you do file an I-140 under national interest waiver, in the past, only a month ago, you were not able to do so based on you were not able to do so because there was no premium processing option. And just so those of you who are not aware, the premium processing will allow you to have a result for your I-140 in 15 business days. It used to be 15 calendar days. Now it's 15 business days. So within 15 business days, you will have the approved I-140 and can then, put that in the bank so that, you are basically protecting yourself and your family with both EB3, if that's the situation you're in, or EB2, or those of you who are on an OPT or any other status. National interest waiver is a very, very powerful, tool again to utilize.
Okay, sir, if we're talking about national interest waiver, just to let people know, this is Attorney Shah Peerally and Attorney Sharif Silmi. We are from the Shah Peerally Law Group, and we are talking about national interest waiver. If you need help, 510-742-5887. But the big question, Sharif, for those who are new listeners, tell us, what is a national interest waiver? What we are talking about here in simple terms.
Before that, Attorney Shah and Attorney Sharif, we have a caller who'd like to ask you a question.
Okay, sure.
Let's take that call. Hello, you're on air with Attorney Shah Peerally and Attorney Sharif.
Hey, hi Shah. I have one question.
Yes.
So my question is once you apply for I-485 and when you get your EAD and your final action date is still not current, so after your EAD approval, do you still have to maintain your H-1B status, or until your final action date is current and your final green card is or 485 is approved? And can you interchangeably use EAD and H-1B? How does that work?
Okay, that's a good question. I'll answer it in two parts. In number one, you can, in fact, keep it, but you don't have to. Once you get the EAD, you fall into what we call a period of authorized stay under I-245A, which allows you to stay in the U.S. and actually get an EAD and work. So that means you don't need an H-1B. However, it's not a status. If you want to maintain a status, although it's not necessary, you will have to keep the H-1B. The reason it's recommended to keep the H-1B, it gives you a lot of more flexibility in terms of possible issues that can happen to your I-485. But it also has its own disadvantage to keep the H-1B. That means you're basically at the mercy of the employer with the H-1B rules like the salary, etc., etc. So it depends on a case-by-case basis. Right now we're telling people to keep the H-1B just because a lot of people are downgrading and we don't know how this thing is going to work out. Now, to answer your second part of the question, shifting from one to another, it gets a little bit tricky to do that. If you're on H-1B, you can just move to EAD whenever you want to. You just have to inform your employer, they correct the I-9. But if you want to come back to H-1B, if the H-1B is still valid, you have to step outside the country and then come back on H-1B to reactivate it. That's how it works.
I see. So, then in that case, what is the advantage of that? If I still have to maintain my H-1B status just to be safe side until my final 485 is approved. So in the meantime, downgrading to EB3 and getting EAD, how it is advantageous to do so? if I still have to maintain my H-1B?
Well, the advantage of the EAD is not only the EAD that you get the advanced parole, but the big thing you get is something called AC-21 Section 104C, the portability of the case. Right now, when you're moving from one company to another, you have to, every time you want to get a green card, you have to file a new a new labor certification and a new I-140.
Mm-hmm.
Having this possibility of filing the adjustment of status gives you, after 180 days, the ability to move to a same or similar position. However, it has its own weaknesses. You have to move to a same or similar position. And this is why Attorney Sharif was talking about this earlier. Having a national interest waiver gives you a lot of more flexibility. So that means you take that national interest waiver with you, plus you take the entire case. And then if the EB2 becomes current, we just shift the I-45 to the national interest waiver. So the advantage of this, the biggest advantage is AC-21 Section 104C, which is basically you can move the entire case from company A to company B. Okay?
And the AC-21 104C, when one moves from one company to another, the subsequent employer, can you explain their responsibility just so the callers understand in terms of I-45 Supplement J? And
Definitely. The Supplement J, and they have to put you in the same or similar position, which becomes a little bit an issue because many of those EB3 that were obtained were back in the 2010, 2011, and most people were doing a different kind of, were basically doing different things. That they are going to do now, because now at that time we had cloud computing or whatever things they had at that time, and now we have different things. So you might not be able to get the same or similar position. Having said that, it is an advantage because if you can do that, then the company doesn't have to go through the entire process of labor certification again. So what you do, just you take the entire case, you bring it here, and then you wait for your green card. And you can do that as many times as you want, as long as you meet the two requirements. 180 days has passed, and you move to a same or similar position. So it has its advantage, big ones. Yeah.
Okay, so I can start using the EAD to change the job, and by the meantime, like I can also ask the employer to submit and maintain the status of my H-1B.
Exactly. And you can take two jobs too. But one of the companies has to make sure that they sign the Supplement J to confirm that once you get the green card, you'll work for them. Okay?
I see. So it is not like if I use my EAD, then my H-1B is not valid anymore.
The H-1B is not valid in terms of status, but you can reactivate it by leaving the country and coming back. Yes, Sharif, you were saying something?
Well, I just want to explain to the caller and to other people's, for everyone else's benefit, that this is a great example of why a national interest waiver is important. Because here, in this case, the individual is thinking about downgrading to EB3 and is questioning why one should downgrade to EB3 and is thinking about all the risks and benefits. Well, let me tell you something. If you have the ability to maintain an EB2 and your EB2 priority date and benefit from the EAD, from the adjustment of status on the EB3, it's going to make your process a lot easier to decide, because this way you're benefiting from the best of both worlds. So I think in this particular example, and I'm so glad that he called in to get the clarification, you are a perfect case of somebody who would benefit from having an EB2 and an EB3, because my fear for you, and I don't know what your priority date is or what your situation is exactly, that would take a deeper dive, is you downgrade to EB3, you get the adjustment of status filed, you eventually get an EAD card, but then you're going to be in a limbo situation for a very, very long time. And, the final action date will never come current, and maybe what if EB2 comes current and EB3 retrogresses? Then, I hate to say it, but you've just, you've put yourself in a worse situation. So to prevent that from happening, you really, really need to think about the benefits of the national interest waiver, because this will really, really protect you, and you will not be at the mercy of the future employer. Because what's going to happen is, let's say after 180 days, you switch jobs based on having the EAD. then the future employer says, oh, well, I don't need to do your I-140. It's already done. It's very easy. You're just working on EAD. And then you're going to ask them for I-45 Supplement J, and they're going to tell you, what do you mean I-45 Supplement J? You came to our company with an EAD card. The only reason we hired you is because we didn't have to deal with any immigration headache. Go find one on your own. Then what are you going to do?
Yes, exactly. That's one thing that we are facing a lot, because people, they are not, the AC-21 is very important to keep that green card, right, if you're moving from one company to another. Because if you use EAD, you will get more job offers, but at the same time, they might not really support you when it comes to Supplement J, which means there's no parking for the green card. I call it a parking, like an example. You have to park your car somewhere, right? So if you don't have that, then you lose the green card too, and they won't do anything for you, so you're stuck. So having the national interest waiver kind of protect you. Of course, if you qualify for it, Sharif, we have to go over this. But I think hopefully the caller is still there. I don't know, but you got an idea what we are talking about here. Bottom line, keep your H-1B right now until new orders, but you don't have to keep it if you don't want to. Okay?
All right. Yeah. Thank you.
Well, thank you. I hope that answers your question.
I think we gave him a lot of information, so let's hope we are able to digest that. Because
honestly, the bottom line that you gave, that you keep your H-1B, but if you don't want to, you don't have to. I think that kind of answers it, and because you gave him a gist also that this is what the bottom line is, and this is what you should do. This would what our advice would be. We have another caller. Let's see what they'd like to ask you, and then let's move on from there. Hello, you're on air with Attorney Shah and Attorney Sharif.
Hi. Thank you for the great conversation. Basically, my question is around this one. I have a company A that had filed for my I-140 that was approved, and things were fine. I moved into a company B that is in startup now. I get a 3 years automatic H-1B extension, but my fear is that say if this company B, which is in startup, they have started my reform processing, but if they go south, and by the time my 3 years are up, they don't have I-140, and I have to change company now. I go to company C. Assuming that I only have less than a year still on my current active H-1B, can I get another 3 years of extension when I transfer from company B to company C based on my company A's I-140? I hope I'm not confusing you.
No, I got it. So, yes, the answer is yes, you can. But now with the new rule, you might not get 3 years, but you'll get 1 year. Definitely you can use an I-140 from any company to move you to get your extension. However, if the dates become current, that becomes questionable. That's where the issue becomes big, right? If the dates become current and you're trying to get a transfer, right, you will... And you might not get it because a transfer and an extension fall under the same section. You need to have that I-140 in your hand if you pass the 6 years. Now, you can use the same I-140 from company A, but if the dates you're reaching, let's say you're moving to company C, and if the dates become current, USCIS have a right to refuse you to grant you that extension. Doesn't mean they will, but they have a right to. Because they give you the AC-21 just for that.
Most likely that will happen. My dates will become current because they are current now. But then just because I've changed now, I can't basically apply for that.
Well, this is exactly one thing we were talking about. Maybe you should look into the national interest waiver.
Are your dates current under EB2 or EB3?
I'm under EB2.
And the dates are current?
I mean, my date of filing did become current. I changed job about 3 months ago, and just now my date of filing did become current, yes.
Yeah, I think. So, do you have a master's degree?
Sorry?
Do you have a master's degree?
Yes, I do. Yes.
Yeah. So I strongly suggest that you call our office, and we can provide you the phone number and schedule an initial consultation. There may be some things that you're unaware of that we can help you with.
Awesome, that'll be really great. Actually, can I? I will keep listening, and I'll get your number. And,
sure, you can call the office after the show. It's 510-742-5887.
742-5887.
Yeah. Otherwise, you can just log on to the website if you don't remember the number later on. It's peerallylaw.com. PEERALLY. peerallylaw.com.
It's P as in Peter or B
as in Peter? P as in Peter.
Okay.
Thank you very much for calling in. Listeners, if you also have any questions, please feel free to call us right away on 510-657-1170. That's 510-657-1170. We have our next caller. Let's see what they'd like to ask you. Hello, you're on air. Please go ahead.
Yeah, I have one question. So the AC21 date actually considered from the AOS filing, or it's according to your EAD?
It's from the I-45 filing. Not really, because when the law was written, it was when I-45 and I-140 was filed simultaneously. But technically, because of the situation we have now, it starts from the date of I-45 is filed. But this is where it gets tricky. It's not about waiting 180 days. It's about 180 days will be completed, right? And this is where people don't get a little bit confused. But to be on the safe side, people will wait 6 months and then they will move. But let's say you move the next month, you can still do that as long as the company doesn't cancel it within the 180 days. But there is another thing now. The I-140 cannot be cancelled under the Obama new rule. So, but still the AC21 holds, so it's from the I-45 is filed, the adjustment of status. Just to be on the safe side, keep it the 6 months, not 6 months, 180 days, and then you move, okay?
Got it. Thank you. Thank you very much.
Okay. Yeah, today we're getting very technical. Sharif, this is before we take other callers, let me have Sharif talk a little bit. I want him to talk about the national interest waiver, because a lot of people don't even know that thing exists, because it's not something that they see every day. They've been so used to one path, they don't know there are so many other good paths out there. Sharif, talk about that, please, because this is major.
I think that previous caller was a great example of that, where you have people who are, doing great work. They're doing, startups. They're on the forefront of, technological advancements. They have, advanced degrees, but they don't necessarily know all of the rules and the immigration process. And that's why it's important that you at least, consult with a experienced licensed attorney. And, you can always call us and we'll help you with that, because, this is your life is on the line, and you want to make sure that you're putting yourself in a successful position. So understanding the national interest waiver is very, very important. So first of all, the national interest waiver is one of two categories of immigration that are self-petition, meaning you do not need an employer to file it on your behalf. You can break out of that locks of being locked down by the employer and are able to file it on your own. Now, the employer can file your national interest waiver, so it can be an employer-sponsored, but it can also be a self-petition, where you don't need to involve the employer at all. That's the first thing that you need to understand. The second thing you need to understand about a national interest waiver, it is an EB2 category employment-based visa. EB2 national interest waiver. Now, the requirements for the national interest waiver are usually that the individual applying has a master's degree. If you do not have a master's degree, we can still file your national interest waiver, but there are some other things we need to prove. For example, if you have a bachelor's degree and 10 years of professional experience, for the most part, you can overcome the requirement of having a master's degree. So either you have a bachelor's degree, 10 years experience, and at least one other criteria, which I don't want to get into too deep now, but it's basically if you have the bachelor's degree and 10 years experience, you'll be fine. And or you have a master's degree. So those are the two options. master's degree or 10 years experience plus bachelor's degree. So once we've overcome that initial requirement, the national interest waiver is based on a case called DANASAR, DHANASAR, and under DANASAR, there are 3 requirements for one to qualify for the national interest waiver. The first is that they work in an area that is of national importance and substantial merit. So here, with the first requirement, the focus is not necessarily on the individual applicant as much as it is on the work or area of work that the applicant is involved in. So, for example, if you are in the pharmaceutical arena, and maybe, we have a lot of folks who do drug trial optimization using, AI and what have you, machine learning. So let's say you're optimizing drug trials. That is an area of national importance. It is an area that, that is advancing U.S. interests. And at the same time, it requires one to be of a certain caliber, of having merit, having, importance in their own careers. Not anyone off of the street or fresh graduate of college will be doing this kind of work. It will be something that a more highly advanced individual does. So national importance, substantial merit. That's the first requirement. Now, the second requirement for the national interest waiver, the focus shifts. So first, we are focusing on the area of work that you're involved in. And then secondly, we are focusing now on the individual's capability. So this is called that you are well positioned to advance the area of national importance that was identified. So first, we identify an area of national importance, and then secondly, we are finding how you are personally well positioned to advance that area of national importance. All right. So that is what the national interest waiver is all about. And then the third and final requirement is a balance test. So the question for the balance test is first to best understand it, and this is kind of a different way to think about it than you might find in the forums or, on these websites and what have you. A different way to think about the balance test is, why do they call a national interest waiver a waiver, right? What are you waiving? You are waiving the requirement of having a perm labor certification, right? Because remember, you have no job offer requirement. You have no employer sponsor requirement. All of that is being waived. So the government is saying, okay, friend, we are willing to waive your requirement of having a perm labor certification. We're willing to waive the requirement of having a job offer. On what basis are we waiving all of that? The basis that we are waiving all of that is in the national interest of the United States. So here it's a balance between the benefit that you are providing through working in an area of national importance, being well positioned to advance the area of national importance, and how that relates to U.S. interests versus protecting U.S. workers through the labor certification process. So it's a balance. What is more favorable to U.S. interests? That we protect U.S. workers through the labor certification process, or that we advance U.S. interests by having this highly talented individual remain permanently in the U.S. Of course, we have our strategies. We have our very highly advanced, well-developed arguments that are uniquely tailored for each individual case. So it's not, and some people get frustrated with me about this, but I don't have a checklist that I can give you. That's going to tell you exactly what you need in order to meet this or pass this balance test. It takes thinking. It takes deep thought. It takes strategy. And that is what we provide each and every individual that applies, through our services. So make sure that you are thinking deeply about these questions and, have your case evaluated so that we can, present it. But those of you who may have listened to the radio show or regular listeners probably have heard a lot about EB1A, and you can almost think of the national interest waiver as a pit stop along the journey of EB1A. So if EB1A is a very, longer journey, right, that takes, great efforts and great evidence and what have you, probably less than, halfway along that pathway is where one qualifies for a national interest waiver. You don't need necessarily to have publications or, even like salaries can be flexible. You could be a little bit earlier in your career. I could tell you off the bat, any postdoc will qualify for a national interest waiver, with hands down. Okay. And any product developer, somebody who's creating great products, who's earning lots of money, doing well in their career, who has a master's degree, you will qualify for a national interest waiver. Anyone who is in, pharmaceuticals, healthcare, most part you're going to qualify.
Okay, Attorney Sharif, we have a caller over here. Right? We do have a caller here. Hello, you're on air. Please go ahead.
Yeah, I have a question on my H1B visa status. So right now I am on L1B visa and I have an approved H1B. So if I have to switch the company on my approved H1B, is it possible for another company to transfer my H1B even though I am on L1 visa right now?
Okay, let me ask you the question. Have you activated the H1? You never used it, right? You just got it and you just kept it like that. Is it the consular processing?
That's correct.
Yes. Yeah, it is possible. What you will have to do is call a new employment cap exemption, moving from L1 to H1. However, it's always a little bit tricky when you do that. It's always good to activate the H1, move to H1 first, and then you go ahead and you use then you actually you go ahead and transfer it. But yeah, it is possible. It requires some work, and there are some glitches when you do that, some issues. Okay.
Okay. So is there a risk of getting it denied, the transfer, if I do not
it can get denied because they might think that you never activated, so that means it's not really a genuine offer. But it's very rare if you're working for the same company that is having the L1 and the H1. What I would recommend is when you file it under premium, let it be approved, then you move.
I see. Okay. All right. Thank you so much.
Good luck to you. Anyway, you cannot move until it's approved in your case because you're moving from L1 to H1. Okay. Good luck to you. Wish you all the best. And if you need help, give us a call. So, Sharif, I think we have another 5 minutes to go, right, Ara?
Yes.
So I want you to kind of talk a little bit about, this is a very important point we're talking today because we're going really deep into the reasons of having a national interest waiver, but people can also, when they come to us, we can look into an EB1, right?
Absolutely. And, I was just kind of alluding to that when we were talking about the national interest waiver. Oftentimes, I've done many cases like this where one, obviously is interested mostly in an EB1A because that's going to resolve all of their problems. It will get them the green card and everything will kind of be great. So we kind of point ourselves to an EB1A, but along that journey to the EB1A, we find ourselves able to file for national interest waiver. So that is really an ideal scenario because this is what I call all of the above scenario, where let's just take the example of somebody who's doing a downgrade to EB3 with adjustment of status. If that person is really savvy and wants to make sure all of his or her interests are taken care of, they will go forward with a national interest waiver and an EB1A if they qualify, obviously, if they're in that class of individuals who can qualify. And this will give them the possibility of having qualification in all three employment-based criteria, and nothing contradicts it. It's completely permissible, and actually, there's nothing that stops you from it. As long as you are willing to undertake the efforts and energies that it requires, we can definitely, assist you in that regard. So those of you who feel strongly about your profile, and, let's say you have definitely anybody. I was kind of mentioning a list of areas where we've been successful, but I would say the number one area we're successful is product creators. I mean, anybody who's involved in creating technology products, you can basically bank on, if you're probably commanding a high salary, you have original contributions of major significance to your field, maybe you've been asked to review and judge the work of others outside of the normal course of your employment, you command a high salary, as I mentioned, you have professional memberships, you probably can argue that you perform in a critical role for an organization that has a distinguished reputation. These things will basically get you the EB1A, and at the same time, there's a symbiotic relationship between the EB1A and the national interest waiver. So, for example, part of the EB1A is that you demonstrate that you will prospectively benefit the United States, that you're going to bring about future benefit to the U.S. Well, this sounds a lot like working in an area of national importance, right? Prospective benefit to the U.S. means future benefit to the U.S., that you work in an area of national importance. These things are very closely related. So there's a lot of overlap between the national interest waiver and the EB1A, and there's a lot of overlap in various categories of immigration. I think we see that all over the place, whether it's immigrant, non-immigrant, if it's an O1A or an EB1A or L1B and an H1B. I mean, there's overlap all over the place. And here, when we're talking about EB2, national interest waiver, and EB1A, the beauty of it is this is all self-petition. You don't need to even inform your employer. This is something you can do on your own without the involvement of the employer. So it's really, really important for you to take advantage of these things and put yourself in the best position for you and your family to be successful.
Exactly, Sharif. And since we are almost done now, I wanted to recap to people today, because a lot of people, as you know, because of the visa bulletin, have jumped onto the EB2 train, and now we are having some possible downfall of that, although there are good stuff of doing it, and we encourage people to do it. At the same time, you need to have a backup, and this is what we were talking about today with Attorney Sharif, Silmi. And if you need help on any immigration matter, by the way, whether it's labor certification, downgrading, but mostly like the national interest waiver and the EB1 or O1 visa, you should look into that, because it gives you a lot of independence, and that's what you want now, independence, right, Sharif? So you have 30 seconds, Sharif, if we can close this, and I think we are done for today. I wanted to thank you all for listening. Anything we told you today is our opinion. You should not act or refrain to act solely on information provided. You should contact an attorney if you have any questions. Sharif, one last word before we finish.
Sure. Last word as a recap. If you are downgrading to EB3, you have a single labor certification, you must absolutely look into the possibility of filing a national interest waiver under EB2. You are doing yourself a disservice if you do not do that. It is very, very important for you and your family. That is, you at least get your profile looked at. At least look at it and determine whether it's a possibility.
Thank you so much, Sharif. Thank you, ladies and gentlemen. We'll be back next week. Please subscribe to our YouTube channel, youtube.com/Shah Peerally Law. We will repost those shows on there, and you can share it with your friends. Thank you so much. Take care. Bye-bye. We'll be back next week.
Thank you, gentlemen, for being here, and thank you, listeners, for tuning in. Remember, you can call them on 510-742-5887, 742-5887. Log on to the website peerallylaw.com, PEERALLYLAW.com. This is Ira signing off. Have a beautiful Wednesday.